I discussed the D.C. Circuit Court of Appeals decision, which held that Trump did not have absolute immunity from criminal prosecution for acts committed while he was president after he left office. I'm linking that video in the more section below. The criminal charges in this case relate to Trump's alleged efforts to corruptly subvert the election results and to interfere with Congress's acceptance of the certified state election results on January 6. Trump claims that his unlawful actions to overturn the election results and to remain president were official acts that cannot be criminally prosecuted, even when he is a private citizen when the charges are filed against him. Trump also claims that these charges were the subject of his second impeachment, and the Senate failed to convict him of those charges, a political process that has no evidentiary standard, and he consequently claims he cannot be charged again for the same crime, a frivolous double jeopardy argument. A related argument that he makes is that he must first be convicted of impeachment before he can be charged criminally. When discussing the well-reasoned D.C. Court of Appeals decision, I previously predicted that the Supreme Court would take the case for review. Many pundits thought it was possible that the court would simply affirm the decision of the D.C. Circuit Court of Appeals. My thinking, as previously discussed, was that the case was too important to avoid Supreme Court review, particularly since it was a case of first impression. No other president had ever been charged with felonies for acts committed while president, and parameters of what is and is not protected need to be set by the Supreme Court. Nixon would have been criminally charged, but Gerald Ford pardoned him before the indictment could be made by a grand jury. First, let me emphasize that executive privilege and the immunity from civil suits arising out of official acts, which are subject to prior decisions of the Supreme Court, are judge-made doctrines and are not sourced from anything specific in the Constitution. The same would be true for any immunity from criminal prosecution for acts alleged to be official acts. I use the word alleged since that is the question that the Supreme Court has framed to be decided. The issue is not, as framed, include Trump's arguments that he has to be indicted and convicted before being charged, or that he has suffered double jeopardy by being criminally charged when the Senate failed to convict him of the crime. The Supreme Court framed the issue so that those frivolous arguments would not be briefed or subject to their review. If the judge creates a criminal immunity from criminal prosecution for acts committed while president, it will be viewed by about 1/2 of the population, maybe slightly more, as being a judge-created political decision made by Republican ideologues who wear robes in order to protect Trump. Most of the other half will view it as correct since it protected Trump from being, quote, unjustly, unquote, punished in their view, an opinion formed without looking at the evidence supporting the criminal charges. I don't think it's possible to have a fact-based discussion of those charges with any Trump supporter. I would view any expansion of the presidential immunity doctrine to protect the president from criminal prosecution after leaving office to be a dangerous, very dangerous, and unwarranted judge-created constitutional doctrine that may easily end America's democracy and result in authoritarian rule in this country. Millions will favor that result, provided it is an authoritarian government that implements their favored policies. The Republican justices in particular fall into what I call the imperial presidency camp of judges. Power is increasingly being concentrated in that office through judge-created rules. As to the motives for taking up the immunity case, that is a fruitless exercise, in my opinion, to discuss. There are legitimate reasons why the Supreme Court would decide the case. I would just say here that the delay in making a decision and the leisurely briefing and oral argument schedule does make it highly likely now that there will be no trial before the election, even if the Supreme Court affirms the D.C. Circuit. And that may or may not be the desired result of some of the justices on the court. The district court trial could not occur within several months after the Supreme Court decides the case. The judge is going to give the parties more time to prepare for trial. And consequently, I doubt that the judge would hold a trial, a criminal trial, where the defendant has to attend just before the election. So the case is going to be tried, if at all, after the election. By failing to take the case as requested by Jack Smith in December of last year, as a result of a direct appeal from the federal district court decision that would bypass the appellate court, which the Supreme Court could have done, and the Supreme Court's lack of urgency in deciding the case after the appellate court decision, Trump will achieve an objective that he desires, which is no trial on the alleged insurrection and election subversion case before the November 2024 election. And if he wins, he will order his Attorney General to dismiss the special prosecutor, which can only legally be done for just cause, but what does legal mean anymore? And then dismiss all criminal charges against him. Willingness to do so would be the only job qualification for Trump's Attorney General.